The Commission is required to grant registration to any broker-dealer that meets all of the rules of the Securities Exchange Act of 1934. However, one of the requirements is that in order for the SEC to grant registration, the member firm must be a member of the Registered Securities Association that we have in the U.S. called FINRA, which we've said. So the broker-dealer can't be registered unless they are already a member of FINRA. It's also required within 6 months of the date of the granting of registration to be a broker-dealer. The Commission, or FINRA, must conduct an inspection of the broker-dealer to determine whether it is operating in conformity with federal securities laws. So within 6 months of registration, it's basically like an audit. So either done by the SEC or FINRA to make sure that everything's set up the way it's supposed to be set up. The SEC, by order, can censure, place limitations on the activities of, or suspend a broker-dealer for a period not exceeding 12 months. So if a firm is suspended, the longest a suspension can take effect is for 12 months. But the SEC can also revoke the registration if, after notice and opportunity for a hearing, so this comes up again and again, you can't lose your license without an opportunity for a hearing. You have to be given notice. These rules must be followed. If the SEC finds that the suspension or revocation is in the public interest and that the broker-dealer, whether prior or subsequent to becoming a broker-dealer, or any person associated with the broker-dealer, whether prior or subsequent to becoming associated with, has. Okay, so once again, we get these long lists, and darn it, I wish the law wasn't written this way, but that's just how it is. So we have to know what these things are that could cause the broker-dealer to be suspended for up to 12 months or to be have their registration revoked. Mostly common sense. Has willfully made or caused to be made in any application for registration or report required to be filed any statement which was at the time and in light of the circumstances under which it was made false or misleading with respect to any material fact, or has omitted to state in any such application or report any material fact which is required to be stated. So if the broker-dealer intentionally lies or intentionally omits something that is important on their application, that's grounds for censure, suspension, or not denial of a license, not being able to get licensed at all. They also like this one, this sounds familiar, has been convicted within 10 years preceding the filing of any application for registration, any felony or misdemeanor or of a substantially equivalent crime by a foreign court of competent jurisdiction which the Commission finds. Okay, so let me kind of clean up the law. So it's any felony in the past 10 years or a misdemeanor or substantially equivalent crime in a foreign court that involves the ethical things, the moral things that we mentioned before. So the purchase or sale of a security, the taking of a false oath, the making of a false report, bribery, perjury, burglary. So those sorts of things in the previous 10 years that are misdemeanors can affect the ability to be registered as well. If the misdemeanor involves the larceny, theft, robbery, extortion, forgery, counterfeiting, fraudulent concealment, embezzlement, fraudulent conversion, or misappropriation of funds or securities. All of those are bad, even if they're done outside the U.S. So foreign jurisdictions apply as far as breaking the rules that will affect the broker-dealer's ability to be licensed. If the broker-dealer applying for registration, or if any person associated with the broker-dealer is permanently or temporarily enjoined by order, judgment, or decree of any court of competent jurisdiction from acting as an investment advisor, underwriter, broker-dealer, municipal securities dealer, municipal advisor, government securities broker, government securities dealer, and on and on and on. So a person that is associated with a new broker-dealer can't be barred from being involved in the industry. They just can't, which makes sense. If any person associated with the firm or the broker-dealer has willfully violated any provision, willfully violated is bad, of federal securities law, whether or not we're talking about the Securities Act of 1933 or the Investment Advisors Act of 1940, the Investment Company Act of 1940, or the MSRB rules, which is the Municipal Securities Rulemaking Board. That would affect the ability for the firm to be registered. They could lose their registration for any of those things. Has willfully aided, abetted, counseled, commanded, induced, or procured the violation by any other person of any provision of federal securities law. Also bad. Has been found by a foreign financial regulatory authority to have made or caused to be made in any application or in any proceeding before a foreign financial regulatory authority with respect to registration, any statement that was, at the time and in light of the circumstances under which it was made, false or misleading. Same rule that we have when they apply for registration domestically. So if they've done these things in their foreign registration, it affects their ability to be licensed here in the U.S. If the broker-dealer or an associated person of the broker-dealer is subject to any final order of a state securities commission, that has an effect on their ability to be licensed. So use mostly common sense. Some of the ones that I would be really sure of, foreign regulatory bodies will affect the ability to be registered. That's really a big one here. So any felony in the past 10 years or a misdemeanor that's securities related. The Securities Exchange Act of 1934 also has other rules about accounts and records. So every member of a national securities exchange, broker, dealer, registered transfer agent. So the transfer agent's also defined in this act is the person who keeps track of who owns the issuer's shares, transfers ownership. Registered clearing agency, registered securities information processor, National Securities Exchange and National Securities Association shall require that each of its partners, directors, officers, and employees be fingerprinted and shall submit such fingerprints or cause the fingerprints to be submitted to the Attorney General of the United States for identification and appropriate processing. So not only do the associated persons of broker-dealers get their fingerprints done, but the employees of national securities exchanges get their fingerprints done as well. Of FINRA have their fingerprints done as well. Of a registered securities information processor have their fingerprints done as well. Transfer agents. So fingerprint information, we already talked about, it's part of the U4 form process application that you get your fingerprints done. So I always know right off the bat, if someone doesn't know that they have to get their fingerprints done, that they're not far enough along really in the process as far as you kind of want to start opening up your window, file the U4, get your fingerprints done, and then you want to listen to me. And if you haven't done that yet, then plan on listening to me for a little bit longer because it sometimes takes a while. Usually someone within the compliance department of your firm can tell you how long it takes at this current moment to open up the window. So it's part of the application process. So fingerprint information. FINRA says that if the U5 is filed, it's possible that FINRA can make a registration effective for an individual pending the submission of fingerprint information. But if the member firm does not submit within 30 days after they file the U4 form, then the person's registration will be deemed inactive. So they can't. You have to submit your fingerprints within 30 days. So if you're going to be a registered rep, it's really just part of the process. But they'll say this idea that FINRA can grant registration pending receipt of fingerprints within 30 days. And if they don't receive it within 30 days, then you're going to have to get your fingerprints submitted before you can act as a registered person. We talked about the rule that says that you can't be licensed if you're not engaged in the securities industry. We talked about if you're not engaged in the securities industry, if you leave the firm, they'll file you 5 within 30 days, and that if you're not active for a period of 2 years and you want to get back into the industry, you have to retest. So we know that. The Investment Advisors Act of 1940, I briefly introduced that, but here's a little bit more. So the Investment Advisors Act of 1940. Be very careful here. So investment advisor, we mentioned they apply for registration by the filing of Form 80V. This is the firm level. If you end up needing to be registered as an investment advisor representative, you will still do a Form U4 to apply for that registration, and you will be what is called an IAR, an investment advisor representative, right? Series 65, Series 65. So a whole nother class, lots and lots of information presented to you there. I'll see you for that class. So the investment advisor is the firm level, which is kind of opposite of how we talk in the real world. A lot of times we say go talk to my investment advisor, and you mean your friend, who's the investment advisor representative, actually. So the Investment Advisors Act of 1940 requires that any person who charges a fee for investment advice be registered as an investment advisor. So person being broadly defined, and in this capacity, we're really talking about at the firm level. So within the Act, the actual big long definition goes like this. Any person who, for compensation, engages in the business of advising others, either directly or through publications or writings, as to the value of securities, or as to the advisability of investing in, purchasing or selling securities, or who, for compensation and as part of a regular business, issues or promulgates analysis or reports concerning securities. So if the firm writes research reports on securities, they fall within the definition of needing to be registered as an investment advisor. If you give investment advice, you say it's a good idea to buy this, a bad idea to sell that. Investment advice, that's what this is all about. Now, within this federal securities law, we have some situations in which we are not going to require, or these people are not investment advisors. So excluded from the definition of investment advisor, banks. Banks are banks. But I swear, I can see a sign that says the bank's name, and then at the end it says investment advisor. It's actually an entirely different legal entity from the bank. The bank is the bank, it's not the investment advisor. And we'll talk more about how that might work out in the real world later. So banks are not IAs. We also have a little acronym that helps us remember certain types of professionals that are excluded from the registration requirements. It's LATE, L-A-T-E. It stands for lawyers, accountants, teachers, and engineers, are excluded from the definition of needing to register as an investment advisor if their performance of such services is solely incidental to the practice of their profession. So my finance professor taught me how options work, and I went home and traded based upon what I learned in class. I don't have, my teacher's not registered as an investment advisor. If my professor was meeting after class with his students and giving them investment advice, well then that's not solely incidental to their job anymore. Registration would be required. Not every broker-dealer is an investment advisor. If you kind of go back in time, because investment advisors are very prevalent today, but let's say 20 years ago, there wasn't nearly as many. So 20 years ago, your stockbroker called you every morning right before the markets opened and suggested that you buy or sell certain securities every day. It wasn't that they were charging a fee for the advice, it's that they wanted you to say yes so they could charge you a commission on the transaction. So brokers, right? The broker side of broker-dealer, they make commissions. If the broker-dealer also charges a separate fee for investment advice, or sometimes they do what they charge a wrap fee, which has transaction plus advice all put into one, then the broker-dealer must also be registered as an investment advisor. But not all broker-dealers must be investment advisors. If the advice they give is solely incidental, they receive no special compensation, then they're not investment advisors. Who else is excluded? The publisher of any bona fide newspaper, news magazine, or business or financial publication of general and regular circulation. Bona fide, authentic. So Fortune, Money, Kiplinger's, Investor Business Daily, Wall Street Journal, they're not investment advisors. If I wrote a newsletter, Susie's Hot Tips, and I sent you an email and I told you what to do every Friday, Monday, whatever, charged you a fee for that, that would require that I have a firm that's an investment advisor. As an individual, I can own my own firm, and then I would need to be registered as an investment advisor representative as well. Also excluded from the definition of investment advisor is any person whose advice, analysis, or reports relates to no securities other than securities that are issued by the U.S. government or agency issues like Ginnie Mae, Freddie Mac, Sallie Mae, Fannie Mae. If the only advice you give is to buy U.S. government securities, how boring and how safe. You're not registered as a federally registered investment advisor. Any nationally recognized statistical rating organization is also excluded. Rating organizations are things like Fitch's, S&P. So Standard & Poor's is a rating organization. They're not investment advisors, no. Now, the only thing I've said so far about registration is that Form ADV is filed to register an investment advisor federally. However, some investment advisors register at the state level. So what's called the National Securities Markets Improvement Act of 1996, when it was passed, what it did was it eliminated the need for an investment advisor to register both federally and at the state level. It says certain firms are federally covered investment advisors and the rest are state registered. So the National Securities Markets Improvement Act, the Act of 96, first introduced this idea of a federally covered investment advisor. And then the Dodd-Frank regulations came along and gave us new limits, new dollar amounts for when is federal registration required and when is state registration required. So we need to know a little bit about this. But I want to say something first. We're going to learn later on in the course all about investment companies. Mutual fund companies are a type of investment company called a management company. And the largest expense of a mutual fund is the investment advisory fee. I just want to show you why this matters. Why does all this matter? Why do I have to know all this stuff? Sometimes I think it helps to understand the why behind it. So it is a really important topic because it's the largest operating expense that the mutual fund will have. The investment management fee, it's an investment advisory fee. So which investment advisors must register federally? So we have federal registration of the investment advisor. All IAs of a mutual fund must register federally, all of them. As well as investment advisors that have assets under management. So all of the current market value of the money that they manage, assets under management of 100 million or more. So these are what we call federally covered, federally registered investment advisors. Federally registered investment advisors. Oh, I suppose it's also true if you manage hedge funds. Hedge fund advisors, they also register federally. I doubt that'll be on your test. The rest are going to register at the state level. And today, most investment advisors are state registered. So firms that have assets under management of less than 100 million. So most investment advisors register at the state level. So Form ADV is still filed. It's still filed electronically through the Investment Advisor Registration Depository. It's just a matter of what box in the form is checked. Is this for federal registration or is this for state registration? Are they registering in more than one state? If so, then you check all these different boxes. So federal versus state registration of the investment advisor. Now this is really this rule, this threshold when a firm is new. So a firm is new and expects to have 100 million or more in assets under management, or they're going to manage a mutual fund. They must register federally. Under 100 million, state. Now think about, your retirement account, for example. I was having a conversation with my brother about retirement account balances the other day, and I said, oh yeah, I usually check mine quarterly and then I make a little graph and whatever. I'm kind of a nerd that way. And he said, yeah, I look at mine annually. Sometimes life just happens, right? What are we hoping happens to the money in our retirement account every time we look at it? That it gets bigger, right? Not only from contributions going in, but from growth in the account. Same idea, that the investment advisor hopes that the money that it's managing gets bigger over time. When is it going to change? When is the balloon going to change? Every single day. Never will a firm have to change where it's registered any more frequently than once a year. So what they need to do is, once they filed Form ADV, so this is the initial rule, 100 million or more, mutual fund, hedge fund, federally, under 100 million, state. And then every year they do an annual updating amendment to their Form ADV, and they might have to change where they're registered. So this is the rule for how that works. So at the time of filing the annual updating amendment, so generally speaking, we talked about this $100 million rule, yes? So 20% of 100 million is 20 million. So what we're going to do is we're going to make a box, and we're going to go down by 10 million and up by 10 million, okay? And then I'll teach you the rule for at the time of the renewal. So if a firm was SEC registered, so federally registered, okay, and at the time of the annual updating amendment, so it's like a renewal, but they don't call it a renewal, of course. At the time of the updating amendment, assets under management are less than 90 million. What do you think they're going to have to do? They're going to have to go from being federally registered with the SEC and switch to state if their assets under management are less than 90 million. Now, the opposite is also true. If the firm was state registered and at the time of the updating amendment, assets under management are greater than 110 million. What are they going to have to do? They're going to have to switch to be federally registered. So let's say the firm was state registered, and here they are at the time of their annual updating amendment. They're at $107 million. Do they have to switch? No. Could they choose to switch? Yes. But they don't have to switch until they're over 110. Just like if they were federally registered, and now at the time of the annual updating amendment, they find that their assets under management, let's say, are $96 million. Do they have to switch? No, they can stay federally registered. But if it falls below 90 million, then they must switch to state. So that's kind of a funky rule. But heck, that's my job, to teach you funky rules. It's just the way the test goes. You can do it. It's unlawful for any investment advisor, unless they're properly registered, to make use of the mails or any means or instrumentality of interstate commerce. So we have the same rule for broker-dealers. Broker-dealers cannot engage in interstate transactions, sending things through the mail, unless they're registered. They have to be properly registered. We also have some situations in which investment advisors do not need to be registered federally. So it's important to notice that the firm itself can't just not register anywhere. If they're not required to be registered federally, then they must register at the state level. So no matter the size of assets under management, these situations require the investment advisor register at the state level. An investment advisor whose clients live entirely in their home state and whose only advice they give is to buy securities registered in that state. So the advisor's in Georgia, all the clients are in Georgia, and the only thing they give advice on is to buy securities registered in Georgia. How boring would that advice be? That investment advisor would register where? In Georgia. If the investment advisor's only clients are insurance companies, insurance companies are regulated state by state by state, so it makes sense that the investment advisor to the insurance company would also register at the state level. If the investment advisor has assets under management under $100 million, it registers where? State, not federally. Or any person whose advice, analysis, or reports relate to no securities other than U.S. government securities or agency issues. So that was one I said earlier was excluded from the definition federally. So if the only advice you give is to buy U.S. government securities, you as an investment advisor still register, but you register where? State. How does the firm register? What do they file? Form ADV. So ADV is filed electronically through the IARD. It includes the following information: the name and form of organization under which the investment advisor engages or intends to engage in business, the name of the state or other sovereign power under which the investment advisor is organized, the location of its principal business office, any branch offices, the name and address of any partners, officers, directors, persons performing similar functions, or if it's a firm owned by an individual, the name of such individual, the number of the firm's employees, the education, the business affiliations for the past 10 years, and the present business affiliations of such investment advisor and of its partners, officers, directors. The nature of the business of the investment advisor, including the manner of giving advice and rendering analysis or reports. A balance sheet that must be certified by an independent public accountant, and any other financial statements. The nature and scope of the authority of the investment advisor with respect to clients' funds and accounts. The basis upon which such investment advisor is to be compensated. So oftentimes they charge a percentage of assets under management, but they can charge an hourly fee, they can charge a flat fee. Also found on Form ADV, whether such investment advisor or any person associated with such investment advisor is subject to any disqualification which would be a basis for denial, suspension, or revocation of registration of such investment advisor. A statement as to whether the principal business of such investment advisor consists or is to consist of acting as investment advisor, and a statement as to whether a substantial part of the business of such investment advisor consists or is consisting of rendering investment advice. So there's no such rule about you have to register as an investment advisor if more than X number percentage of your business is, no. If you give investment advice, you must register as an investment advisor whenever there is compensation for such advice, or the writing of research reports, those sorts of things like we discussed before.